Question 1. A California notary is asked to notarize a document that will be filed in another country. The document needs an apostille. The notary's responsibility is to a. Obtain the apostille from the Secretary of State on behalf of the signer. b. Notarize the document as usual if the notarial act is one they are authorized to perform. c. Refuse to notarize any document intended for use outside the United States. d. Add a special, for foreign use, statement to the notarial certificate. Answer: b. Notarize the document as usual if the notarial act is one they are authorized to perform. The correct action is to perform the requested and lawful notarization, such as an acknowledgment or a jurat. A notary's duty is limited to the notarial act itself. Obtaining an apostille is a separate, subsequent process handled by the California Secretary of State to authenticate the notary's commission for international use. For example, after the notary completes the notarization, the signer is responsible for sending the document to the Secretary of State for the apostille. Always remember your role ends with the properly completed notarization. You are not responsible for the document's next steps. Question 2. If a notary's official seal is lost, stolen, or damaged, the notary must notify which entity? A. The local county clerk's office within 10 days. B. The Department of Motor Vehicles immediately. C. The Secretary of State immediately, in writing. D. The vendor who manufactured the seal within 30 days. Answer: C. The Secretary of State immediately, in writing. A notary is required to provide immediate written notice to the Secretary of State if their official seal is misplaced, lost, stolen, or rendered unusable. This is a critical security measure to prevent fraudulent use of the notary's seal and commission. The law emphasizes immediacy to ensure the state can quickly flag the compromised seal. A helpful tip is to treat your seal like a credit card. If it goes missing, report it to the issuing authority without delay. Question 3. What is the maximum fee a California notary public may charge for taking an acknowledgment? A. $10 per signature. B. $15 per signature. C. $15 per document. D. $10 per document. Answer: B. $15 per signature. The maximum fee for an acknowledgment is set by law at $15 for each signature being acknowledged. This fee is charged per person signing, not per document, which is a key distinction. For instance, if a husband and wife both sign the same deed and each needs their signature acknowledged, the notary can charge a total of 30. 15 by 2. A good way to remember this is to connect the fee to the individual act of verifying and acknowledging each person's signature. Question 4. A credible witness used to identify a signer must: A. Be personally known to the signer but not the notary. B. Present a valid, unexpired identification document to the notary. C. Be personally known to the notary and swear or affirm the signer's identity. D. Be a family member of the signer. Answer: C. Be personally known to the notary and swear or affirm the signer's identity. A credible witness must be an individual whom the notary personally knows and trusts to vouch for the identity of the document signer. This witness must take an oath or affirmation administered by the notary, confirming the signer's identity under penalty of perjury. The core concept is that the notary's personal knowledge of the witness provides a reliable chain of trust to identify the signer. Think of a credible witness as a human link in the identification chain, one the notary must know personally. Question 5. A notary public is prohibited from notarizing a document when they are A. Real estate agent in the transaction. B. Mortgage loan originator in the transaction. C. Grantor or grantee in the document. D. All of the above. Answer: D. All of the above. A notary cannot perform a notarial act on a transaction in which they have a direct financial or beneficial interest. This includes situations where the notary is a party to the document, such as a grantor, seller, or grantee, buyer, on a deed, or an agent or originator whose compensation depends on the transaction's completion. The guiding principle is to avoid any conflict of interest that could compromise the notary's required impartiality. As a rule of thumb, if you stand to gain something from the document being signed, you must step aside. Question 6. A notary's official journal must be retained for what period of time? A. For the duration of the notary's current commission. B. For 10 years after the date of the last entry. C. Indefinitely, it must never be destroyed. D. Until the notary retires or resigns their commission. Answer: A. For the duration of the notary's current commission. A notary public is legally required to keep their journal of notarial acts for the entire term of their commission. Upon commission termination, such as resignation or retirement, the journal must be delivered to the county clerk's office where the notary's oath is on file within 30 days. This ensures a permanent and public record of the notary's official acts is maintained even after they stop practicing. Think of the journal as a state record you are temporarily responsible for during your commission. Question 7. When a signer executes a document using a signature by mark, how many witnesses are required? A. 1 witness, who must sign the signer's name. B. 2 witnesses, one of whom must write the signer's name next to the mark. C. No witnesses are required if the notary personally knows the signer. D. 1 credible witness who must also sign the journal. Answer: B. 2 witnesses, one of whom must write the signer's name next to the mark. The correct procedure for a signature by mark requires 2 witnesses to observe the signer making their mark. One of these witnesses must write the person's name next to their mark, and the other witness must sign their own name on the document as a witness. The notary cannot act as one of these witnesses. This 2-witness rule ensures there is no dispute about who made the mark or what name it represents. Question 8. A jurat requires the signer to A. Acknowledge that they signed the document. B. Swear or affirm the contents of the document are true. C. Prove the signature of a third party who is not present. D. Certify a copy of their driver's license. Answer: B. Swear or affirm the contents of the document are true. The core purpose of a jurat is for the signer to swear or affirm, under penalty of perjury, that the statements in the document are true and correct. The notary must administer an oath or affirmation to the signer and witness them sign the document in the notary's presence. The key phrase in a jurat certificate is, subscribed and sworn to, or affirmed, before me, indicating both signing and swearing occurred. Always remember that a jurat is about the truthfulness of the document's content, while an acknowledgment is about the identity of the signer. Question 9. When a notary changes their business or residence address, they must notify the Secretary of State. A. Within 30 days. B. Within 10 days. C. Immediately. D. Before the next notarial act is performed. Answer: A. Within 30 days. California law requires a notary public to notify the Secretary of State in writing of any change to their business or residence address within 30 days of the change. This ensures the state has accurate contact information for the notary at all times. Failing to do so can result in fines and is considered a breach of notarial duty. A simple memory aid is to connect the 30-day timeframe to common billing cycles, making it a monthly administrative check-in for your notary commission. Question 10. Which of the following documents can a California notary certify a copy of? A. A United States passport. B. A birth certificate. C. A power of attorney. D. A driver's license. Answer: C. A power of attorney. A California notary is authorized to certify a copy of a power of attorney. State law explicitly grants notaries this power, which is an exception to the general rule that notaries cannot certify copies of public records like birth certificates or government-issued IDs. For a copy certification of a power of attorney, the notary must make or supervise the making of the copy and then certify that it is a true and correct copy. Remember this exception: while most copy certifications are off-limits, power of attorney documents are a specific, allowable act. Question 11. The term of office for a California notary public is A. 2 years. B. 4 years. C. 5 years. D. 6 years. Answer: B. 4 years. A notary public commission in California is valid for a term of 4 years. The commission begins on the date specified in the commission certificate and expires exactly 4 years later. It is the notary's responsibility to track this expiration date and complete the reappointment process before it lapses to avoid any interruption in their ability to perform notarial acts. Think of it like a voter registration or driver's license renewal cycle that happens every 4 years. Question 12. A notary public who willfully fails to keep their official journal as required by law may be subject to a civil penalty of up to A. $500. B. $1,500. C. $2,500. D. $10,000. Answer: C. $2,500. A notary who willfully fails to properly maintain or secure their official journal faces significant penalties, including a civil penalty of up to $2,500. This high penalty underscores the critical importance of the journal as an official record for public protection against fraud. The word willfully implies the failure was intentional or with reckless disregard for the law, which warrants a more severe consequence than a simple mistake. A key takeaway is that proper journal keeping is one of the most serious duties of a notary. Question 13. Which of the following is a key element of an acknowledgment? A. The signer must sign the document in the notary's presence. B. The notary must administer an oath to the signer. C. The signer must declare to the notary that they executed the document. D. The notary must personally know the contents of the document. Answer: C. The signer must declare to the notary that they executed the document. For an acknowledgment, the signer must appear before the notary and affirm that they indeed signed the document. Unlike a jurat, the signer does not have to sign in the notary's presence; they can sign it beforehand and then bring it to the notary to acknowledge their signature. The core function of an acknowledgment is to certify the identity of the signer and the fact that they signed willingly. An easy way to distinguish this is to remember, acknowledgment means the signer is admitting to their signature. Question 14. A notary changes their name by marriage. What must they do to continue performing notarial acts? A. Continue notarizing under their old name until their commission expires. B. Immediately start using their new name and order a new seal. C. File a new oath of office and bond under the new name within 30 days. D. Inform the Secretary of State but wait for a new commission to be issued. Answer: C. File a new oath of office and bond under the new name within 30 days. Upon a legal name change, a notary must file a name change application with the Secretary of State and, once approved, obtain an amended commission that reflects the new name. They must then file a new oath of office and a new bond, or an amendment to the existing bond, with the county clerk within 30 days of the amended commission date. The notary cannot notarize under the new name until these steps are completed. Think of a name change as a mini-recommissioning process that requires updating all official records. Question 15. The official notary seal must contain all of the following information except A. The notary's commission expiration date. B. The county where the notary's oath and bond are filed. C. The notary's commission number. D. The notary's business address. Answer: D. The notary's business address. A California notary's official seal must include the words "Notary Public," the notary's name as it appears on the commission, the state seal, the commission number, the commission expiration date, and the county where the oath is on file. A notary's address, whether business or residential, is not a required element of the seal. This ensures the seal remains valid even if the notary moves within the state. Always check your seal to ensure it has all the required elements and nothing extra. Question 16. A California notary public is required to maintain a $15,000 surety bond. What is the primary purpose of this bond? A. To protect the notary from lawsuits resulting from their official acts. B. To provide a limited source of funds for members of the public harmed by the notary's misconduct. C. To pay for the notary's commission fees and administrative costs to the state. D. To ensure the notary's official seal and journal against loss or theft. Answer: B. To provide a limited source of funds for members of the public harmed by the notary's misconduct. The correct purpose of the $15,000 surety bond is to protect the public by creating a fund to compensate individuals who suffer financial loss due to the notary's negligence or intentional misconduct. This bond is not insurance for the notary but rather a form of consumer protection required by the state. For instance, if a notary's error on a property deed causes financial harm to a signer, the injured party can make a claim against the bond to recover their damages up to the $15,000 limit. It is crucial to remember that the bonding company will seek reimbursement from the notary for any claims paid, which is why notaries often purchase separate errors and omissions insurance for their own protection. Question 17. A proof of execution by a subscribing witness may be used when A. The principal signer cannot appear before the notary. B. The document is a grant deed or mortgage. C. The subscribing witness is a party to the document. D. The signer refuses to present identification. Answer: A. The principal signer cannot appear before the notary. A proof of execution by a subscribing witness is a notarial act used when the person who signed the document, the principal, is unable to appear before the notary to acknowledge their signature. Instead, a subscribing witness, who saw the principal sign or heard them acknowledge their signature, appears before the notary on the principal's behalf. This act is prohibited for certain documents like deeds and mortgages. Think of the subscribing witness as a proxy who can vouch for the signature when the original signer is unavailable. Question 18. A notary is asked to notarize a document in a language they do not understand. The notary should A. Refuse to notarize the document. B. Notarize the document if the notarial certificate is in English. C. Use an online translator to understand the document's content. D. Ask the signer to provide a verbal summary of the document. Answer: B. Notarize the document if the notarial certificate is in English. A notary is permitted to notarize a signature on a document written in a foreign language as long as they can communicate with the signer and the notarial certificate is in a language the notary can read and write, typically English. The notary's duty is to certify the signature, not the contents of the document itself. Therefore, understanding the foreign language text of the main document is not required. The golden rule is that you must be able to understand and properly complete the notarial wording you are signing and sealing. Question 19. The penalty for failing to deliver a notary journal to the county clerk upon commission cessation within the required 30 days is a misdemeanor and can result in a fine of up to A. $1,000. B. $2,500. C. $5,000. D. $750. Answer: C. $5,000. A notary, or their personal representative, who fails to deliver the official journal to the county clerk within 30 days of the commission's termination can be found guilty of a misdemeanor and face a fine of up to $5,000. This severe penalty highlights the journal's status as a crucial public record that must be preserved by the county. The law ensures there is a strong deterrent against misplacing or destroying these important records after a notary leaves office. Remember that your final duty as a notary is to ensure your journal is properly surrendered. Question 20. When administering an oath or affirmation for a jurat, the notary must ensure that A. The signer raises their right hand. B. The signer places their hand on a religious text. C. The signer personally appears before the notary. D. The signer has read the document aloud. Answer: C. The signer personally appears before the notary. The most fundamental requirement for any notarial act, including a jurat, is the personal appearance of the signer before the notary at the time of the notarization. For a jurat specifically, the signer must sign the document in the notary's presence after taking an oath or affirmation. While raising a hand is a common custom, it is not legally required. The essential elements are the signer's physical presence and their verbal commitment to the oath. A key tip is that, before me, in the notarial certificate means physically face-to-face. Question 21. Which statement is true regarding advertising notary services in a foreign language? A. It is prohibited to advertise in any language other than English. B. The advertisement must include a statement that the notary is not an attorney and cannot give legal advice. C. A notary may use the literal translation of notary public, such as notario publico. D. Foreign language advertisements are only allowed in newspapers. Answer: B. The advertisement must include a statement that the notary is not an attorney and cannot give legal advice. If a notary advertises their services in a language other than English, the advertisement must include a clear disclaimer, in the same language, stating that the notary is not an attorney and cannot give legal advice about immigration or any other legal matter. This rule is designed to prevent notaries from misleading the public, especially by using the term notario or notario publico, which in many Spanish-speaking countries refers to a powerful attorney. The purpose of this disclaimer is to protect consumers from unauthorized legal practice. Question 22. A notary's geographic jurisdiction is: A. The county where their oath and bond are on file. B. Limited to their city of residence. C. The entire state of California. D. The United States and its territories. Answer: C. The entire state of California. A California notary public has statewide jurisdiction, meaning they can perform notarial acts anywhere within the borders of California. While their oath and bond are filed in their principal county of business, their authority to notarize is not limited to that county. For example, a notary from Los Angeles County can travel to San Diego County to perform a notarization for a client. Just remember, your commission allows you to operate throughout the state, but not outside of it. Question 23. A notary is presented with a document that has blank spaces where information should be. The notary should: A. Instruct the signer to fill in the blank spaces before notarizing. B. Leave the spaces blank as it is the signer's responsibility. C. Fill in the spaces with information provided verbally by the signer. D. Notarize the document but make a note in the journal about the blanks. Answer: A. Instruct the signer to fill in the blank spaces before notarizing. A notary must refuse to notarize a document that is incomplete or contains blank spaces where material information is clearly intended to be inserted. The correct procedure is to have the signer either fill in the blanks or line through them and initial the deletions before the notarization is performed. This prevents fraudulent insertion of information after the document has been notarized. Always remember the rule: never notarize an incomplete document. Question 24. A notary may be held liable for: A. Any misstatement in a document they notarized. B. The financial consequences of a transaction they notarized. C. Damages caused by their negligence or official misconduct. D. The signer changing their mind after the notarization. Answer: C. Damages caused by their negligence or official misconduct. A notary can be held legally and financially responsible for any damages that result from their own negligent actions or intentional misconduct while performing their official duties. This liability is tied directly to the notary's failure to follow the law, such as failing to properly identify a signer or completing a false certificate. For instance, if a notary knowingly notarizes a forged signature on a property deed, they could be sued by the rightful owner for the resulting financial loss. This is why following all notarial procedures correctly is essential for protecting both the public and yourself. Question 25. An acceptable form of identification for a notarial act must be current or, if expired, have been issued within the last A. 1 year. B. 3 years. C. 5 years. D. 10 years. Answer: C. 5 years. California law allows a notary to accept certain identification documents, such as a driver's license or passport, even if they are expired, provided the ID was issued within the past 5 years. The ID card must contain a photograph, a physical description, a signature, and a serial number. This 5-year grace period provides a practical solution for signers whose identification may have recently lapsed. A helpful tip is to always check the issuance date on an expired ID, not just the expiration date, to confirm it falls within the 5-year window.